Judges go through years of law school and practice to handle a criminal, but no school will prepare them to deal with a courtroom Karen.
She was put on notice that there was going to be...
Even you don't testify to that.
An application.
The best you have testified to about notice is, I do believe there was talks about application.
Exactly.
But I'm reading your words, right?
Exactly.
But I don't recall telling her specifically how the process works.
She was on
notice. That is not putting her on notice, Mr. Paulino. She's going to have to fill out a 10-page thing that asks her to list.
She can't go down to the condo place and get an application?
It's not.
This is standard practice, Your Honor.
Okay, Mr. Paulino, you're dead wrong.
That's your opinion.
No, that's my ruling, pal. And let me tell you something, Mr. University of Miami Law School. I taught at UM for many, many years, and you right now are embarrassing us. You do not show that kind of disrespect, okay? If you don't like what the judge is doing, then you take it to the next forum. But you do not sit here and say that's your opinion like a baby when a judge rules against. Don't even utter another word. You've got a lot to learn about what it means to be a litigator and a lawyer.
I don't want to be either.
Good, because you don't have it in you. But you got a lot to learn about what it means to be a member of the Florida Bar. And if you think that this kind of petulance and babiness on your part, to turn around and tell a judge who you disagree with, well, that's your opinion, is going to get you anywhere, you are sorely mistaken. If there's nothing you should have learned in the last 2 years as a law student, there's something you should have learned as a human growing up, that you do not show that kind of disrespect. You don't like it, take it to the hallway. But you do not look a judge in the face, because I don't care what you think about me. You got to respect this process. And if there's anybody who I expect to respect this process, it's a second-year law student at the University of Miami. Verdict for the plaintiff, $450 and court costs.
When he lost hope in the justice system, this prosecutor had no choice but to shine the bat signal.
I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
She chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff will...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
I have prepared my remarks and my decision here today, and I am, I guess, I am glad I had the opportunity to spend the night to do some deliberation on this matter and think about it.
You guys will just take his side. I'm an African American woman. I'm a black woman, and you guys are all white. You can say you're not racist as much as you want until you're blue in the face, but your actions say otherwise. Okay. And it's clear that you don't have children yourself because of the decisions that you make.
Okay. So here's what I'm going to say. So, Mr. Lytle, I want to make sure that I reinstate her contact, and we're following the order that was entered by Judge Marquis.
That's what you said yesterday, and you didn't
listen
deliver.
to me.
You didn't deliver on
Ms. Sangalasa,
you're going to be held in contempt, and the next time you...
interrupting what
held
the
in
judge is trying to say to
for
Mr.
speaking.
Lytle.
I'm a pro
You
se
had your
litigant.
chance to
I'm a
talk.
pro se litigant, and it's my
Okay.
right to
Oh, my
speak.
goodness.
As a judge, you have no right to shut up a pro se litigant, and that is in the Constitution, the Nevada revised statute.
Okay, all right. So we're supposed to just let you talk however long you want.
Yes,
Okay.
as a
All right, so
litigant,
here's the
I'm
deal.
not represented by
Here's the
any
deal.
counsel. I have
Ms.
the right to speak.
Sangalaza, we're going to... I mean, I've let you go on far longer than I would let anybody else. And so here's what I'm going to say. You're going to get compensatory time for the time you just missed this week. Now, this is what's going to happen. Mr. Lytle.
It's not just this week. It's a whole month.
Well, he lost a lot of time, too. We'll deal with the law.
No. It's a whole
Hold on.
month.
Stop. I will deal with the compensatory...
You took away my right to breastfeed my child. It's been more than just a week. It's been a month.
I understand.
I
understand.
No, you don't understand. You can't say you understand and you say the exact opposite. I'm not taking this.
All right. So here's what I'm going to do. I'm going to tell the order. So here, I understand you've missed time, and I understand you are entitled to compensatory.
You don't understand.
I do. So
No.
here's what. Listen. So for this week, the compensation is going to be as follows. On Friday, she will receive the child, let's say 10 a.m. And that's going to be at the police department, and that's on MLK, correct, Mr. Lytle?
Yes.
Okay.
No,
No. Yes.
In the prison courtyard, some will be in for murder, some for theft, and some for having a very big mouth.
Good morning, Ms. Burks.
Good morning.
You're charged with assault. That's a misdemeanor 1, carries a possible fine of $1,000 and or 6 months in jail. Domestic violence is also a misdemeanor 1 and carries a possible fine of $1,000 and or 6 months in jail. You have 3 pleas available to you today: guilty, not guilty, and no contest. You also have the right to a lawyer, and if you can't afford a lawyer, the court can appoint one for you. What plea would you enter?
Not guilty.
Court will accept your plea of not guilty. I'm going to assign your case to one of the courtrooms. All right, Ms. Burks. On the domestic violence, I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Cedric McRae. On the assault, I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Tiffany Castro. No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him. If you go someplace and either Mr. McRae or Ms. Castro's there, you have to leave. If you're someplace, even though you may have arrived first and one of them shows up, you still have to leave.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with
I'm talking. I don't need you to say nothing.
If you live with Mr. McRae, you cannot return to that residence.
Oh, but how you just gonna tell me I can't go home now?
What?
How you gonna tell me I can't go to my house?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not going. You're not what?
Whoa.
Get back! Get back!
You just said I got
Get back!
I'm not getting nothing else.
That's another 30 days. That's 60 days.
So what?
90 days.
So?
120 days.
Okay, and?
180 days.
Whoa!
Please, quiet.
Get off me! Get your hands off me, man.
Come on.
What else you got to say?
Oh, nothing. We'll talk in 6 months when you're ready to come back for your case.
Sorry, Your Honor.
Not as sorry as she's going to be.
This judge committed an arson crime himself with a major burn to the attorney.
The 18th of July is going to be the day. You see it in Cher's text. She knows he's coming in town. The baby shower. The 18th is going to be the day I'm supposed to be there, but I'm not. I'm in Batesville, and I'm calling Billy. Every time. And they do it without me. And I know it because they show up at my house. Metal detector. Cut the barbed wire fence. Look for the gun. Go to the lake with Billy and throw the gun away. Shotgun shells, wire clippers, everything. It's all the same. And it's been the same literally for 10 years. Through 20 interviews.
Objection, Your Honor. This mischaracterization of this is a proper argument to your argument. You may proceed, Mr. Okay. I'm sorry, Mr. Perry, did you say something?
I didn't say a
Mr.
word.
Perry, I told you about that attitude. You would not, under your breath, be disrespectful to this court, sir. You argue things he has a right to answer when I overrule your argument. Have you sat down and said, of course it is? It is a proper. I didn't say of course. Mr. Perry, it's a proper argument to your argument. You may proceed, Mr. Asherman.
Yes, sir.
Karen law is usually limited to free sandwich rights, but when you use it to defend bank robbery, this happens.
The issue here was the enactment clause. All that was a diversion. I'm talking about the enactment clause under our Constitution. Okay. Michigan Constitution, 1963, Article 4, subsection 23. What it states, it's mandatory. You know this.
Mr. Rory?
Okay. I'm sorry, I'm getting high strong again. But I love the Constitution. Yeah.
Take it down. But no, I didn't know. I mean, I know I schooled you on it, but I didn't know you would then go and listen to me. So, all right. I just wanted to make sure.
Okay.
The statute would say we the people of the state of Michigan enact, and then would go into the statute. The complaint is then going to basically apprise you that you have violated this statute that the state of Michigan, or the people of the state of Michigan have enacted. So you got that just a touch bit wrong.
Okay, correct.
All right.
But it should say enactment clause, because this lets me know the authority.
It doesn't have to, but go ahead.
It doesn't have to, but
No, it doesn't have to.
Your Honor, I'm not even in no position to say anything. You know the law, but I'm just saying from what I'm reading in the Constitution and what it says and what Supreme Court justices have stated on the matter.
All right.
Okay? That's all I'm saying. I don't know nothing but what I read and what I interpret. I think I'm pretty intelligent enough to interpret the English dictionary.
Yes. Yes. All right.
Yes. So, what you're telling me is that regardless to what, you're going to bend the Constitution to your understanding and how you want to rule it on this, and that you still obtain subject matter jurisdiction. Is that what you're telling me?
Mr. Warren?
Yes, sir.
Never bent the Constitution in any direction. Okay.
This lady was this close to asking for the manager, but this manager can send people straight to jail.
The poll book is completely off. Completely off.
Off by 30,000?
I'd say that poll book is off by over 100,000. That poll book, why don't you look at the registered voters on there? How many registered voters are on there? Do you even know the answer to that?
No, I guess I'm trying to get to the bottom of this here.
Zero. There's zero.
So my question then is, if the
Guess how many? Wait, what about the turnout rate? 120%.
Let's let Representative Johnson ask his question, please.
So the poll book number. There's two things that could happen here. Either the poll book number, if ballots were counted multiple times, there's two options. Option number one is that the poll book numbers are not going to match.
They don't.
The actual. Not by thousands and thousands of votes. That's not what we see right now.
Take a look again. Take a look again.
Option number two is that they essentially were filling in names of people who didn't vote.
Dead people too?
So is that?
Let's let Representative Johnson ask his question, and then when he's done.
I thought that was his answer. Okay.
Well, I guess that's my question here is why we're not seeing the poll book off by 30,000 votes. That's not the case.
What did you guys do? Take it and do something crazy to it?
I'm just saying the numbers are not off by 30,000 votes. So
I know what I saw.
Saying that they're filling in?
I know what I saw, and I signed something saying that if I'm wrong, I can go to prison. Okay. Did you?
I'll say if they ask you to leave, you have to leave.
My money's in this bank, and I'm going to take it out.
Well, then you have to abide by the rules, and you have to have a mask on.
This is a state.
It's not. Exactly. Businesses have the right to refuse service, even if you're not wearing a mask. That's their choice.
My money out.
Awesome. Well, you need to go and get a mask and then take your money out. You're not allowed to do.
I've been waiting here.
Ma'am, listen. We're going to do this the easy way or the hard way.
What are you going to do? Arrest me?
Yes, for intruding on premises.
That's hilarious.
That's exactly what it is.
Yeah, and you believe in this?
I believe in it.
Do you believe in this?
The laws, yes.
The law says that I do not have to wear a mask.
You can not in public, but you're not in public. You're not in public.
Yes.
I'm not going to argue with you about this. This is not a public place. This is a private business. No, you're not. We're going to go outside.
Are you serious?
Do I look like I'm kidding?
Well, I don't know, because
let's go walk outside.
You've got some issues.
I've got issues.
That you're taking away people's human rights.
Okay. Let's go outside.
Let's go outside. Shoot me, people? Is
no.
he going to shoot me for trying not to breathe?
Cool.
Come on, dude.
Don't do that. Oh no.
Do not touch me. Who do you think you are?
2010, one resisting.
Back up. Some old lady is getting handcuffed here. There, people. Ow.
Ma'am, put your hands behind your back. Say, you don't stop resisting. Stop.
Is anybody gonna get real here? Really?
Relax.
No one's gonna get real? Wow.
Come on.
Oh, you're gonna smash my head to the ground now? Now you're smashing my arm into my private area?
Your private area?
Yeah.
Put your hands behind your back.
My hand is behind my back, sir.
This one. Turn over on your stomach. Put your hand behind your back. Relax.
I'm totally relaxed. You're the one.
No, you are not relaxed. Not relaxed at all.
Right here, people. No, it's not. Wow, what a bunch of sheep. Okay, I hope someone's filming this. You're hurting me.
Oh, I'm filming it.
This is like cut.
Yeah,
this
okay.
Is like cutting
Stand up. Stand up. Stand yourself up.
And how do you suggest, sir? I'm like a 65-year-old woman here.
Okay. Sit up.
What are you doing?
Stand up.
Ayúdame, por favor.
Stand up.
Ayúdame, por favor.
Are you trying to speak Spanish to people?
I do speak Spanish.
Okay, well, stand up.
Are you happy now, lady?
Okay.
I'm not happy.
Okay, stand up. Stand up.
I refuse to listen to the...
Come on.
You know what? I think
She's getting your stuff. Come on.
I think...
In the case of State versus Karen, hair pulling and scratching are completely legal, but only...
Good afternoon, Judge. Karen Stevens, in pro per for my motion for sanctions against Mr. Nicoletti for this vexatious and frivolous PPO.
I'm sorry, on this what?
I have a motion for sanctions against...
I know that. And the purpose of the sanctions are based on what?
It was a frivolous and vexatious PPO based on nonsense. I am not stalking Mr. Nicoletti.
I haven't signed a PPO.
His petition for a PPO. Let me.
Okay, were you served?
No, I wasn't. But may.
No, you may not. How can you ask to sanction someone when you haven't even been served?
That's the point.
Stevens, do not interrupt me when I'm speaking, ma'am.
I have a constitutional right to be heard.
On what basis? There is no case before me, ma'am, other than the fact that you filed this frivolous motion, taking up this court's time for no good reason other than your own personal vendetta against this man for whatever reason you may have, and I really don't care because it does not involve me or my court. However, had I issued a PPO, you would have a basis to be before me. I did not issue a PPO. He did not pursue his right to a hearing on the PPO. You were never served. And here you are taking up my time so that you want me to chastise him and make him pay money? No, ma'am. Your relief is denied. And in addition to that, I am sanctioning you with costs of $500 forthwith to the county clerk's office.
Karens in the wild have only one strategy to defeat their prey: surprise attack.
Personal life. It's your business. It has nothing to do with
Miss Hardwick.
No.
You will be held in contempt of this court if you become disruptive.
I don't care. I haven't done anything to this court. I haven't done anything to him.
She will be arrested for contempt of the court.
It doesn't make any difference.
You will serve 10 days for contempt of court. Go now.
Get off of me!
Hands behind your back.